Good day mga katikdol. Lain na sab nga topic atong pag-istoryahan karon ug mao ni ang Section 26 of Rule 130 of the Revised Rules on Evidence. Naunsa ni siya ang Section 26. Section 26 of Rule 130 provides that the act, declaration, or omission of a party as to relevant fact may be given in evidence against him. In short, kining Section 26 nag-istorya ni siya about admissions. So nang admissions, niangkon ka sa usa ka sala nga imong gihimo. Niangkon ka sa kamatuoran nga panghitabo through performing an act or by declaration. Ning istorya ka orally or by way of a writing instrument or omitted to do an act contrary to yourself. Muna gitawag na tong admissions. Now, ang admissions is voluntary acknowledgement. Imuhan ang kagustuhan nga mo istorya kas kamatuoran, walay nag-coerce nimo, walay nagpugos nimo. It may be done through expressly or impliedly by a party to a case or by another. By whose statement, the party is bound against his interest. Now, there are two kinds of admission. We have the so-called judicial admission and extrajudicial admission. When we talk of judicial admission, it is if made in the proceedings of the case where it is to be used as evidence. Meaning, gihimo na siya nimo ang pag-angkon during trial or within the court. Again, within the court, kumingon tag judicial admissions. Kumingon tawag extrajudicial admissions if made outside the proceedings of the case. Meaning, nahitabo ang pag-angkon gawas didto sa court. Shall we say, diri nahitabo sa during interview sa media, diri nahitabo during investigation sa investigator of the case. So, muna gitawag na tong extrajudicial. But, please be mindful on extrajudicial admission kay kinahanglan na siya in the presence of his counsel. Otherwise, kana siyang extrajudicial admission nga gihimo karon which is against to himself, is dili siya magamit as evidence against him because of the prohibition under the Constitution or kinahanglan sa na siyang i-follow under sa Miranda Doctrine. Now, as to how made ang admissions may be express or implied. Express imong gistorya mismo or implied based on your action. Nakita nga nitug-an kas kamatuoran mahitungod sa kanang question or relevant facts. Dili pwede nga lain nga issue. Example, moingon ka nga ang problema is naay namatay. Unya ang imuhang admission kay about sa nang lugos. So, dili pwede. It must be relevant to the facts in issue. Or else, ang issue is naay nangawat. Niya ang imuhang giistorya kay miingon ta naay gipatay. So, layo ra. Dili siya relevant to the fact in issue. Kinahanglan ang admission connected siya sa facts in issue. Now, as to form, by an act or conduct, declaration, order or written, or through an omission. So, mo ni ato ang mga pamaagi. Form nga pwede kang moangkon sa sala nga imuhang gihimo. As to their effect against interest, against na nimo. Kay nganong niingon man ta nga kini siyang admissions madawat din nato as evidence. Kay pag inon pa nila wala may buang mo istorya nga nakasala siya. Unya dili day tinuod. So mo ni siya nga naay reason for the rule. So, there is a presumption of trust in the admission in that no person would do an act or declare something which is contrary to his own interest unless such act or declaration is true. So, kinahanglan nga ning istorya man kana tinuod na nga ikaw nakasala. Dili kay pwede magbuhat-buhat kag istorya, idiin mo imong kaugalingon. So, walay tarong tawo nga saktos panghunahuna nga magbuhat ana. So, natay requirements for admission aron madawat nato, matawag nato as admissible as evidence in court. Una, it must be relevant to the fact in issues. Dili pwede nga dili na siya kalabutan sa mga questions or sa mga pangutana sa adjudication sa usa ka kaso. Ikaduha, it must be expressed, certain, definite, and unequivocal. Kay pag ingnon pa nila, a declaration kuno which goes, I am not sure if I still owe money to X or I do not recall having uttered those words or did not act. Maybe I was in error. Are not admissions. Nga naman, dili man na siya matawag nato against your interest. That is considered as your opinion. Ngayon kang kaibaw mo kahinumdum, opinion na nimo. Opinion na nimo. You need to provide the truthfulness of the fact in issue. Next, must not be self-serving. Serving admissions are those made to favor a declarant. So di na pwede nga self-serving. Kinahanglan ang imuhang admissions mahitungod gud sa kamatuoran. Dili kay pwede nga mohatag ang admission diha para ipaisa ang imuhang kaugalingon para mo tilt baron ang scale of justice against nimo. So kinahanglan kung imo lang himuon ay mga supporting evidence, whether it is cumulative or corroborating evidence aron ang imuhang admissions is magamit or admissible as evidence in court.